Hello everyone, if we can just move on to the next slide, please. I was away with friends and the next one, please. And one of them commented that she hated it when people couldn't do their own slides. So I'm going to have to learn. Okay, so today we're looking at last month, if you remember, we looked at NEC specific case law. Today, what we're looking at is case law predominantly from 2022. I think there might be a couple from 2023. So basically, bang up to date case law. There are some themes, but also, as with all case law, what I want you to look out for are matters going from adjudication to what we call a technology and construction court. So that's the court that deals with construction matters, and then going up to the Court of Appeal, because that's showing that, you know, at each stage one party is dissatisfied with the decision and is taking it to the higher level, which is effectively what, you know, lawyers mean when they talk about, you know, risks of pursuing a dispute. So the case law, we've got quite a lot of fire safety defects. They're coming through on the back of the issues caused by Grenfell. Probably the fire safety issues, particularly the cladding issue, is probably not a major point for most of you, particularly those just doing the, you know, the civil engineering. So in that instance, think about these as defects claims rather than particularly about fire safety and or cladding. We've also got a couple of termination cases where the employer has terminated the contractor. This is one area where I always say to you, if you're going to terminate, get your lawyer involved before you do so. It's really important, and these cases reinforce this. Typically with termination, we've got two key things. One, there's a procedure to be followed. Procedure can be different in each case. It also involves, you know, how you serves. The procedure generally involves notices, but also how you serve notices and when they're served. So there are quite a few things to bear in mind in regard to the procedure or the process, and also there are the grounds. So are you entitled to terminate? You've got to get each issue right, and if you don't, then you as the terminating party, or if you're being terminated, the party terminating you will be deemed to have caused the termination and be the one who has to pay any losses resulting from it. So an important topic, and you know, this reflects, or both of these cases, the fire safety defects and the termination, reflects, you know, what, you know, we as a firm dealing with day-to-day construction matters are dealing with a lot. You know, these aren't just cases in isolation. We've got a case on NEC notice of dissatisfaction. If you were here last month, we looked at it then. And we've also got a case on interim payment applications. So that's going to be really important to contractors and subcontractors in the room. So if we can have the next slide, please. So we're starting with three defects cases. This first one, Martlet and Mullally. So Mullally was the design and build contractor in this case. They installed a whole raft of cladding, and there were defects relating to fire safety as regards how it was installed. So that was predominantly workmanship issues, and also how it was fixed, which is often, I think it was a mixture in this case of design and workmanship. And also the type of cladding used, which was a design issue. So very often, you know, this is really common in defects claims. It's usually a mix of design defects and also workmanship problems. So the claiming party had removed the cladding system and replaced it. and the claim was for £8 million. Now that might sound a lot, it is a lot of money, but it covered not only the remedial works, it also included the investigation costs, but also what they referred to as the waking watch, which is the effectively kind of security through the night, but to keep an eye on issues so that they can raise an alarm if that there's a fire or something like that, so that it doesn't get to the stage where the fire services are tackling something that's got completely out of control. Now, if the court had said, look, there's no design error here, it all relates to workmanship, then the chances were that full recovery wouldn't have been allowed. Now, spoiler alert, the outcome was that Martlet recovered the full £8 million. So if we can move to the next slide, please, and we'll see what the court found. In court cases of this type, there's always at least two issues: liability. So is the contractor liable in this case? So that was around, you know, was the design adequate or not? Was the workmanship adequate or not? So you could win or lose on either of those points, and then you look at what's the consequence. Quite often causation is an issue. So, you know, what caused the loss? And then, you know, you've actually got to look at the loss, the quantum, and work out, you know, is it reasonable? Is it far too high? Does it include things that you're not entitled to? So in terms of liability, what the court said was, so we talk about reasonable skill and care. So for an example, whenever we're looking at the NEC form of contract, we look at the design liability and its reasonable skill and care. And I always emphasize, you know, get that X15 clause in, so you are, as contractors and subcontractors, bound by reasonable skill and care rather than the higher level of fitness for purpose. What the court said here was that there was some non-mandatory guidance, but the court said that that was evidence as to what a reasonable contractor would carry out. So that's in terms of the reasonable skill and care. If within your industry, so if it's design, it would be a reasonable architect. Even if you're a contractor, if you're designing, then, you know, the skill and care you should be working to will be that of a reasonable architect. Or if it's engineering design, an engineering designer. But what the court said was this non-mandatory guidance was what a reasonable contractor would have complied with, and that effectively meant that the contractor in this case had not designed to the required standard, and therefore was liable for both breach in regard to design and also workmanship. The fourth bullet point down is helpful. What the court said was that the courts should be slow to criticise claimants who've taken urgent decision on remedial works because of the defendant's breach. So a lot of this is kind of helpful information for future claims that might be brought against parties. And it's, you know, it speaks for itself, and you can see why, you know, in this context, it was, you know, it was an important comment to make, but because it's a court decision, it's binding and applies to other defects claims in the future. In terms of the quantum, the court said that the waking watch costs were not too remote. Now, how we decide if they're too remote, they're not recoverable. In terms of remoteness, they must be reasonable. So would they have been reasonable? Would they have been foreseeable if, when you're starting out the works, when you're signing up to the contract, someone had said, you know, this might happen, there might be a fire risk, you know, we might need, you know, this waking watch, and the court said, yep, that's absolutely reasonable and foreseeable. Also, so the next bullet point down, the court was looking at, well, what cost, you know, does it have to be the absolute cheapest budget? And if you think about it, these are really important issues for a party who is in occupation of a building with defects, particularly defects like these. You can't risk it causing a fire for obvious reasons, but equally, you don't want to do the remedial works until you know how much you're going to recover in the court case. So what the court was saying here was, they're not going to be too harsh on claimants who have to get on and do the work, and then the court's not going to start picking at all the costs and saying, oh, well, you could have saved some money here, you could have saved some money there. And also that bullet point says, it doesn't mean that you have to go for the cheapest remedial solution. And in the context of contractors, subcontractors, sometimes a claimant will invite the contractor or the subcontractor to come and do the remedial work. And in some instances, that might be the cheapest or the best value solution, simply because that contractor, subcontractor is familiar with the works, familiar with the project, with the building. And, so that might actually be the best value way of dealing with things. And quite often in that instance, it's done on the basis that neither party's conceding any liability. It's basically the work is going to be done, and then the parties will sort out, who's liable to pay the cost. Also, the court said that claimants, so the parties who've carried out the work or who are carrying out the work, should consider remedial proposals put forward by the defending party, so in this case the contractor, but do not have to accept them, but they must look at them reasonably. You can't just turn around and say, well, we're not even going to look at those. You have to consider them. And at the end of the day, it's sort of in everybody's interest to try and get the best value solution, because somebody's going to have to pick up the cost at some point. And the final point, as with all these matters, and it applies to both parties, keep a proper paper trail. So if you're the claiming party, inform the other party that there are defects, invite them to come and inspect, ask them what the suggested remedials will be. And if you're the responding party, respond, make suggestions. All of that caveated with the fact that if you're on the responding end of one of these claims, it's likely that you're going to have to get your professional indemnity insurers involved. So the key point there is don't respond to anything until they have authorised that. So you probably have to get, well, the terms of the policies, the insurance policies usually are that you have got to notify them as soon as you're aware of a claim. So do that, or they may be able to say, we don't need to cover this claim. So get them involved, and then typically they will be involved in the strategies to how to deal with things. So next slide, please. So this is a very similar case, so more defects. So this is the oncology department, so Leeds Teaching Hospital, against Lendlease, who was the contractor. So the in the facts, there were issues. Again, it was about fire protection, and also electrical work as well. I think, yes, electrical defects were alleged as well. So the bottom bullet point on the facts, Lendlease arguments, there were fourfold. So they said, first of all, they disputed that the work was defective. Secondly, they argued that approval to a sort of change strategy had been agreed. Thirdly, they argued that because the oncology department at the hospital hadn't put in a remedial solution, by the time of the trial that they had no intention of doing it and therefore hadn't suffered any loss, and therefore contractor didn't need to pay anything. And finally, Lend-Lease suggested an alternative remedial scheme, so similar scenario in that regard to the previous case. The outcome, another spoiler alert, was the oncology department, the hospital, recovered its costs of the remedial work to the original fire strategy. So if we can have the next slide, please. And the reasoning behind this liability was simply that the expert evidence showed that there were defects in the work that had been carried out. And on a practical level, that's how technical defects, particularly design, but also workmanship, are determined at court. So typically each party will have an expert. So if it's an architectural design, you'd have an architectural expert. If it's engineering, you'd have an engineering expert. Someone's totally independent to the project, and they give their expert opinion on whether there are defects in either the design or the workmanship. So the next bullet down, the point about the contractor's liability in light of an agreement to vary the change strategy, the court said no, that's not going to relieve the contractor of liability. It was just a strategy issue, and most of the standard forms of contracts say any approval of anything doesn't abrogate contractor's liability. To do that, you would need to actually vary the contract, which is quite a formal process, needs to be in writing. Quite often it would need to be executed as a deed, etc. On the issue of quantum, so how do you value what the oncology department is entitled to? And of course, bear in mind they hadn't done the work at this point. Again, the court took note of the experts setting out what a reasonable remedial scheme would be and determined what was reasonable on that basis. Finally, the court said that because the work hadn't been done in this instance, the cost of the remedial works would be assessed as at the date of the trial rather than at the time of the breach. And as to the argument that the hospital, realistically wouldn't carry out this work, the court again found against the contractor on that point. So next slide, please. So this is the final defects matter, and this is a matter that involved a claim against the subcontractor ultimately, in circumstances where the owner, so this is LDC owns 3 student accommodation high-rise towers, again problems, defect or alleged defects with fire barriers, fire stopping, water ingress, and a claim was made, as it would be, because remember, privity of contract means if you're the owner of the towers, you will pursue the party who you contracted with, which would be the main contractor. So they pursued Downing, and Downing decided to mitigate its risks and to settle the claim because presumably it felt that it was the case was substantially against it. So they settled for just over £17.5 million. Downing then wanted to pass the claim down to Sheeting, who was its subcontractor, so made a claim against the subcontractor. Now, by the time of the trial, Sheeting was insolvent, so the subcontractor was insolvent, so it wasn't represented. So if you're using this case to your benefit, you can expect the other party to argue that actually they weren't represented. So this case has limited value, but it's still a determination from court. the outcome was that the contractor recovered the settlement from the subcontractor. Oh, I think you've jumped. Yeah, that's it, lovely, thanks. In terms of liability, the court said that what the subcontractor had contracted to was to warrant or basically guarantee that it would not put the contractor in breach of its contract with the owner of the building. Now, the thing to bear in mind here is that quite often such clauses are included as amendments into JCT and NEC. So those clauses where it says subcontractor, quite often it'll say subcontractor has seen the main contract or has had opportunity to see the main contract and warrants that it won't put the contractor in breach of it as between the contractor and the end client, the employer. The problem is quite often subcontractors haven't seen that main contract, and also it's quite wide-ranging to say that you won't put them in breach of any of that contract. So, you know, hopefully this case shows why, you know, you need to actually see the contract if you're a subcontractor signing up to this clause. And ideally, you know, if this clause must be included, you should get the contractor to identify which specific clauses they're talking about, not just have it as wide-ranging as the whole contract. So the clause ideally wouldn't be in, but if it is in, it should say, you know, it won't put them in breach of, you know, clauses 3 and 7 or whatever, so that you can review them and just get to grips with them. So that was how sheeting was found to be liable. In terms of the quantum, the court said in terms of reasonableness, the starting point is the actual cost incurred, and particularly if they're based on expert advice. Obviously, then sheeting can make arguments as to, you know, was this a much higher spec than had been contracted initially, and, you know, all sorts of arguments in regard to duty to mitigate. But, and this is the next bullet point down, you know, again, when it's remedial works, the court's saying it's not going to be too critical about the choices that parties make as to, you know, how to remediate defective works. Also on this one, because typically in construction we have a concept called betterment. So, you know, if a building's been built, it's, you know, 11 years old, the roof starts to leak and a claim's brought against the contractor, a whole new roof needs to be installed, and you would then get an argument about betterment. You know, the party who owns or leases the building, you know, has had 11 years of use and then gets a whole new roof. So there are arguments that, well, actually, the cost of a new roof shouldn't be what's paid by the contractor. It should be less because of this issue of betterment. In this case, the court said no deduction for betterment, where claimant has no reasonable choice in terms of carrying out remedial works. Next slide, please. Okay, so this case, completely different issue. So this is about collateral warranties, and it's about whether a collateral warranty is a construction contract for the purpose of the Housing Grants Construction and Regeneration Act. So quite a novel argument. It's been an argument that's been running in the courts for quite a few years now. And I don't think it was particularly intended when the Housing Grants Act was introduced that collateral warranties would count as construction contracts. And why it's relevant is that they are used by building owners, building tenants, to bring defects claims against contractors and subcontractors. So, obviously in the context of contractors and subcontractors, you'll be thinking of an adjudication to, get your final account paid or get an interim account paid. Nice, really nice quick process. As you're the claiming party, you can kind of carry out all your prep, get some really good submissions prepared, start the process, and to a great extent, that's an ambush on the paying party. Whereas, of course, the tables are all reversed here. It's the owner of the property, the tenant of the property, bringing a defects claim. Very often, as we've already discussed, the defects claim will involve some element of design defects, in which case contractors' PII would be involved, and I suspect they definitely will not be very keen to have adjudication clauses as applying. They would far rather these defects claims proceeded to court so that they have more time to prepare their defence. So in this case, Abby was the tenant of a care home, so basically the operator. So this is a sort of long-term tenant. I don't know what it was, but potentially 10, 20 years. And typically in those tenancy agreements, they would be responsible for maintaining the premises. Simply Construct was the design and build contractor who built the care home for a third-party employer, and then the tenant had stepped in and started running it. Practical completion was October 2016. August 2018, defects were discovered and notified to the contractor. February 2020, the remedial works were completed, and in September 2020, the contractor issued the collateral warranty to the tenant, the party who was operating the home. So you might think, oh, well, the remedial works have been completed, so I'm safe to issue my collateral warranty. And possibly that is what the contractor in this instance thought. However, care home operator, the tenant, Abby, commenced an adjudication to recover the remedial costs, which were just under £1 million. They were successful. Contractor was unhappy with this, so refused to pay. And therefore the care home operator had no option but to start court proceedings, but they're enforcement proceedings. So court proceedings to get the court to say to both parties, this adjudication award must be followed and payment must be made. Next slide, please. So the arguments were all around whether this collateral warranty complied with the requirements of the Housing Grants Act, which say you can only adjudicate if it's a construction contract. So adjudication, the Housing Grants Act, it's all centred around the construction industry. There are no other industries who can use that part of the Act and adjudicate by right, or have that right to interim payments throughout the project. And also, if we kind of look back, quite a long time ago, 1996, the Act was introduced, but it was introduced because what was happening was that particularly subcontractors in the chain would maybe finish a big construction project. Sometimes they might not have been paid anything on the project, but they had to finish it. They couldn't just walk away. Sometimes they'd only been paid a small proportion of what they should have been paid. They finished the work, then they could start court proceedings, and then possibly 12 months later they'd get a date for trial and a determination. Well, that's a long, long time to wait for money. And if you think about it on a personal level, if we didn't get paid on our monthly basis for 24 months, maybe 36 months, I'm sure all of us would be struggling. Maybe some people have got lots of savings, but the vast majority of us would really, really be struggling. So the Act was introduced so that subcontractors and contractors, so everyone in the construction chain who was doing work on site, or carrying out design was entitled to payment by instalments, and if they weren't paid satisfactorily, they could take the matter to adjudication for a very quick 28-day process. None of this, you know, waiting till the end of the project and then starting court proceedings and then waiting 12 months to get a decision from the court. So, you know, hopefully you can see why, you know, the operator of the care home was so keen to adjudicate in regard to defects. And, you know, having pursued defects claims myself through the court, you know, I'm not surprised that they've tried this. And so what the court looked at was what was the wording of the collateral warranty, because there's no magic about a collateral warranty. It is simply a contract between two parties. It's just a little bit of a strange contract because it's not something that's been specifically negotiated direct with the care home. So what it will have been is that the contractor will have been required in its design and build contract to enter into certain collateral warranties with, for example, funders, in this case, operators and tenants. And so the court looked at the warranty and what it said that simply the contractor warranted or promised that, so number one, it has performed, so that's past tense, but it also said and will continue to perform diligently its obligations under the contract. So what the court was looking at here is, what is this collateral warranty providing for? Is it all about looking retrospectively, a requirement that the contractor has carried out its work? Because of course we know that by the time this was all signed, the contractor had actually finished the work, completion had been achieved. But no, the wording says it will continue to perform. Now, to be frank, that's a little bit meaningless in this context, in this scenario, because we know practical completion had been achieved before the warranty was signed off. But the point was, their contract, their main contract, required them to sign up to this warranty, and so that's the wording that was agreed to, even though it doesn't quite fit in with this scenario. It goes on, so at 2 you'll see in the clause said, in carrying out and completing the works, the contractor has exercised, so that's in the past, but it also says will continue to exercise reasonable skill, care and diligence. So you can see where the court was going with this, and what it said was that for this reason, they had decided it was a construction contract because the obligations were ongoing. They weren't all in the past. So contractors, subcontractors, you need to be careful about the wording of your collateral warranties. Try and keep them to the past tense, particularly for people who are only going to get involved after completion. So an operator is a prime example of that. You know, they can't operate the facility until it's been completed. So be careful about that. The court also considered the fact that the warranty was issued after completion, and in some circumstances that fact might have carried more weight and might have inclined the court to say, actually, no, this isn't a construction contract. But because of this very damaging wording, the wording that's underlined, the court said, in this case, it is a construction contract. So just be really careful about that, contractors, subcontractors. Next slide, please. Right, I think I've pretty much covered that. Next slide, please. Right, so this is the first of 2 termination cases. They are both about, so I said earlier, termination's about following a process, which often means serving notices. There might be one notice asking contractor or subcontractor to pull up their socks and start performing better. So, you know, last chance saloon kind of letter notice, and then but in almost all cases there is also a termination notice required. So basically, when we're looking at when we're talking about notices, we're talking about a letter. It's a formal document. We're also talking about something that will have to be served properly. The contract will say how you serve, but usually it's by first class post or hand delivery. Email usually isn't service. Quite often it might be stated as being signed for delivery. My view is, in terms of service, it's about telling somebody or notifying them. It's a notice, so it's not something you want to kind of keep secret or hope that they don't see. So follow the contract, you know, do what the contract requires in terms of service. But also I like to email things as well, just because we tend to use email as the main form of communication nowadays. So, you know, on that principle that you're trying to notify them, you know, I think it's helpful to send an email and say, you know, please see attached, you know, a letter stroke notice served today, you know, or, you know, which will be served, you know, in the next couple of days. But it then means that they've got it. And it also gives the other party the opportunity to say, I still haven't received that postal notice. And if they don't, which then gives you the opportunity to either hand deliver or properly serve it. But if they don't say that and then they try to argue it later, you've got a defence in that, you know, you've warned them that it was coming and they haven't, you know, said, well, I haven't received it. So that's the process. And then there are also grounds. So the contract will set out what the grounds are. You know, typically not doing the work properly, breaching health and safety. These are usually serious defaults for either party, because the premise of a construction contract is that it's a long-term relationship. It might be a framework that's for a fixed period, or, you know, it might be, you know, a piece of work which typically, you know, is several months, possibly several years. So the kind of theory behind it is that the parties aren't supposed to just terminate for kind of fairly minor reasons. So in this case, the problem was around the process. I think it was helped by the fact that the grounds for termination weren't really in dispute. So it was a clear-cut case of contractor behaving badly and the employer, so in this case the council, being able to terminate. They just didn't quite get the process right. So Thomas Barnes was the contractor for a bus station in Blackburn, sorry. The council issued a termination notice by email and by post with regard to delays and basically not getting on with the work. So on the day the email was served and the notice was posted, the council removed the contractor from site. Now, what the contract said was that service of the notice had to be by post. So I think it would have been first class post. So email wasn't proper service. So, you know, as I've said, no problem with sending it by email, but it also needs to go by post. Service by post was permitted, so great, it had been posted. But if you bear in mind, it's posted on, you know, on the day that they're removed from site. So they haven't received that postal notice. So they haven't formally been terminated. They've only been told by email that to expect the notice in the post. So deemed service by post was 2 days after posting, which is fairly standard, but that's what the contract said. If a contract says 3 days, then it's 3 days. So at that point, Thomas Barnes says, well, your termination is ineffective, it's invalid, because we hadn't been notified before you removed us from site. So what they said was, you have therefore removed us from site without terminating, and that's a repudiatory breach. So repudiatory breach is pretty much the party in breach. So the argument in this case was that it was the council in breach, and the argument is a repudiatory breach is pretty much the council not allowing the contractor to complete its works, which, you know, was an argument. You know, council had removed contractor from site before they'd been terminated. So yes, the council was saying, we're not going to allow you to complete. So arguably it was a repudiatory breach. So can we have the next slide, please? The court said there was no repudiatory breach. First of all, and I think it was fairly pragmatic here, it said there was no adverse impact on TB, who's the contractor, because they would have been removed in any event 2 days later, and the council would have been fully entitled to remove them at that point, because that's when that notice would have been properly served. Also, and I think this helped the council a lot, the court found that the contractor had already, at the time that it was removed from site, ceased all meaningful activity on site. And therefore, what the court said was that effectively it was the contractor who was in repudiatory breach. So remember this breach where you are basically saying to the other party, I'm not going to complete the work. So we're kind of going backwards in time, and what we've discovered is actually the contractor was the first party to be in repudiatory breach, because it was the one who just stopped working and basically was saying, not literally but figuratively saying to the council, we're not going to complete this work. So on that basis, because of those particular facts, the court said that the contractor had been in repudiatory breach, so it didn't matter that the notices hadn't been served, because repudiatory breach is a common law right, and it exists irrespective of whether it's included in the contract. So, you know, if you have a verbal agreement and you don't even agree issues regarding termination, as soon as one of the parties stops performing the agreement, they're in repudiatory breach. They're saying, I'm not going to perform it. That's why I've stopped. You have a termination on that basis. You know, had the circumstances been different, so had, for example, the contractor been getting on with the work, but committed a health and safety breach, then the decision here might have been completely different, because the chances are that wouldn't have been a repudiatory breach, particularly if the contractor continued its work following the health and safety incident. So if we can have the next slide, please. So pretty similar circumstances. So this is Struthers v Davies. You'll see it's a TCC, Technology and Construction case. So the Struthers were homeowners. Davies was the contractor carrying out extension works to the Struthers home. There were various issues complained about with regard to Davies. They'd missed the completion date in August. They then failed to carry out any work from December 2015. So, you know, as soon as that starts happening, you're thinking, right, you know, are they effectively in repudiatory breach, i.e. failing to carry out the works? there were defects, so the extension had to be demolished and rebuilt. And by 11th of January, so a month later, Struthers issued a notice of termination and made a claim for the remedial costs and the consequential losses with regard to it. So the contractor argued that the notice of termination wasn't valid. And in this case, it wasn't to do with timing or service. It was to do with the fact that the contract said that such notices had to be served by the contract administrator, not by the client. So Struthers weren't entitled to serve the notice. The contract administrator was the party to serve it. So if we can have the next slide. So, yeah, thanks. So it's still a procedural issue. Has the correct process been complied with? And what the court said, and this is the second bullet point, the termination was not valid. Such notices must be strictly complied with. So this is quite an important case, because what it means is that if the process isn't followed through properly, then the termination will not be valid. And quite often it will mean that by trying to terminate and getting it wrong, the party terminating, so in this case, arguably the Struthers, the homeowners, would have been in repudiatory breach, because they're basically saying to the contractor, we don't want you to do the work anymore. However, again, in this instance, as the court said, the contractor, Davies, was in repudiatory breach on similar grounds to the previous case. So they used, in this case, they used lots of instances. It wasn't as clear cut as contractor just wasn't doing anything, but there were several things that sort of led the court to believe that Davies was in repudiatory breach, i.e. was not going to complete, was not, or was refusing to perform the contract and complete the work. So, you know, first of all, refusing to purchase materials, and secondly, using materials that the homeowners have paid for on other jobs. Also failing to progress the works, instead, you know, finishing work on other projects. And also failing to proceed regularly and diligently. So there's a mix there, which always makes it slightly more difficult to prove. So what you need to be thinking about is, if you're going to be the terminating party in this situation, you need to be thinking about getting emails in place to the party who is not doing the work properly, you know, questioning it, you know, so, you know, we've asked you to purchase these materials and order these materials. You know, we've been told that you haven't. You know, the second one, you know, we've just been told on site today that, you know, you've used these materials on another project. Well, they're ours, we've paid for them. You know, you've removed them from site, where have they gone? So, you know, put those in emails, because then you've got it documented. But also it's helpful, because if you get a response and it doesn't contest, it doesn't dispute what you're saying, then, you know, there can't be any factual arguments about who was doing what. And it just makes these claims a bit more clear-cut. So again, what the court said was that, you know, contractor here was in repudiatory breach. So it was a breach effectively outside of the contract. They were saying to the homeowners, actually, we're not going to bother completing this work. Next slide, please. Okay, so this is about the validity of the interim payment application. Why is this important? Well, it's important to contractors and subcontractors, because under the Housing Grants Act, you're entitled to submit interim payment applications, and the paying party is then entitled to respond with either a payment notice and or pay less notice, setting out what they will pay as opposed to what the contractor subcontractor has claimed for. And effectively, whichever notice comes last is the one that prevails. So if the IPA is submitted and none of the other notices are submitted, then the IPA prevails, and that is the sum that's to be paid. If it isn't then paid, the contractor or subcontractor, whoever's issued it, is entitled to go to adjudication on what we call a smash and grab basis, which is basically we've submitted our IPA, no other notices have been submitted, so we're entitled to be paid. So it's a really good tactical way of getting substantial money for contractor and subcontractor. However, it's really important that the IPA is valid. If it's not valid, then it doesn't have that smash and grab effect. And validity is about it being in the correct form. So it's got to look like an interim payment application, particularly if it's, you know, it's followed a previous one. This should be in similar forms or in a similar format. It's also got to state the sum claimed and the basis of the calculation. And it's also got to be served in the correct way. And it's the service that was relevant in this case. So Hopkins was the M&E contractor on a project campus building at Brighton Uni, and AVB was the subcontractor. As regards the contract, the standard terms, which were Hopkins, the contractor's standard terms, stated that AVB had to submit its application for payment 10 days prior to the valuation date. So the valuation date was the anchor date in the contract. You know, it would be a certain date per month typically. So the application for payment had to be submitted 10 days before that, not 9, 8, 7, 1 or whatever, had to be 10 days. If it wasn't 10 days, then it wasn't compliant with the contract, and therefore it wouldn't be valid for the purpose of a smash and grab adjudication. However, Appendix 6 to the contract, which, and this is really important, had been negotiated between the parties, stated that the AFP had to be submitted 7 days prior to the valuation date. So we have a conflict in the contract clauses. Unfortunately, it would have been far easier if they'd submitted it 10 days, but they didn't. They submitted it 1 day late, so 9 days prior to the valuation date. Hopkins didn't make payment, and as we've already seen, went to adjudication. The adjudicator agreed with the subcontractor, said the application for payment was valid, and therefore they were entitled for the sum to the sum claimed in it. Hopkins, not happy, refused to pay and went to court to get the determination reversed. Spoiler alert, judge held that the interim payment application was invalid, and this shows the vagaries of the dispute resolution system, and the subcontractor appealed. So if we can have the next slide. I've already basically given the spoiler alert. So the Court of Appeal allowed the appeal. So that's basically that they found in favour of the subcontractor. The IPA was valid. What it said, it first of all, it wasn't impressed with the contractor Hopkins' refusal to pay in accordance with the adjudicator's award. And that's the principle by which a party not happy with the adjudicator's award can proceed to court. So the rule is you get the adjudicator's award. With a couple of exceptions, you pay and then and only then can you go to court to get the matter reversed and you get your money back. So the payment after the adjudication award is very specific because, of course, as we've seen, the whole purpose of the Housing Grants Act and adjudication was to preserve cash flow for contractors and subcontractors, the party doing the work, through a project. So that didn't impress the court. Third bullet point down, what the court said was that the subcontractor's AFP was valid because of the principles of contract interpretation, which are that where there's a discrepancy, so is it 10 days or 7, we've got 2 different requirements in the contract, where there's a discrepancy or an ambiguity, the court will look to any terms that have been specifically negotiated. Now, if they've both been specifically negotiated, it's not helpful. If neither have been, ditto. But in this case, as we've seen, the shorter timescale was the one that had been negotiated. So the court said that's the timescale that takes precedence, and that one had been complied with. Interestingly, the court also took account of the fact that the contractor throughout the negotiations did not raise this issue, did not say at any point, look, subcontractor, your AFP is invalid because you haven't served it on the correct date. The first time they referred to that was in the adjudication proceedings. So therefore, the court said they're deemed to have accepted it. So the moral there is that if you're the recipient of an application that you don't think is valid, then you must say as soon as possible, we don't think this is valid. What I would do is, so this is aimed at probably contractors making assessments against subcontractors' AFPs. If you don't think the AFP is valid, include that in your payment notice, but still do a payment notice or a pay less notice within the timescales and in the correct form. But just say, you know, we're submitting this without prejudice because we don't consider it's a valid AFP, but you know, this is how we've assessed it, and make the assessment. And probably the assessment's going to be 0 in that situation. However, what the court wouldn't take into account was that on a previous earlier application, subcontractor had submitted the AFP late, so not within that 10-minute time scale, and the court said actually we're not interested in that kind of historic position. So you know, kind of interesting as to what factual issues the court would take into account there. Next slide, please. So this case was covered last week. So it's a notice of a dissatisfaction that follows after an adjudication award when you are unhappy and the contract used as NEC. You've probably got your solicitors involved. We dealt with it last week, so we'll move on. I think that this slide and the next, Jen. And I think we'll skip this one because it's more relevant to claiming parties in defects claims and this slide. Thanks. So just a few points to mention. So we've got the procurement bill of 2022 is due to receive royal assent later this year. We've got some new JCT contracts being proposed for modern methods of construction and also to take account of the Building Safety Act provisions. Third one, you should know all about these. Try to get contractors, subcontractors, the inflation clauses incorporated into your contracts. My understanding is that inflation's still an issue, so X1 for NEC. And the JCT fluctuation clauses, which again are both are optional. And the final point is the final bullet point. Just to note that there's a growing focus on ESG, environmental, social and governance. So, you know, in your public procurement, you probably find those issues being dealt with. And we've got coming in September quite a big kind of half-day seminar on procurement So that's a bit of a spoiler alert. I've probably spoilt some of Jen's planning there. So I think that's everything. So if we can have the next slide, please. Yeah, that's it. So I'm happy to deal with any questions. If you need to get off, happy if you just want to email me questions and I'll respond to them.
There is just oh sorry, I've got a frog in my throat because I've not spoken for so long. There is just one question, Sarah. So if you're okay, I'll ask you that now, and then if anybody has any other questions, if you want to email Sarah direct, would that work?
Yeah, that's absolutely fine.
Perfect, and thank you so much. So we've got a question from David. Now, in a situation where you have a dispute over responsibility for costs of remedial works for latent defects, how important is it for the claimant, for the purposes of recovering costs, to having notified the defendant of this issue prior to carrying out works associated with the remedial work, e.g. design, tender and carrying out the remedial works?
Yeah, it's generally speaking, it's really important. And hopefully you'll have seen from the cases that we've looked at, it's all fact specific. So, you know, a major health and safety defect, you know, there's less of an obligation to inform the contractor, because at the end of the day, you know, people's safety is more important. But generally, you know, if you're being accused of defects, you know, what you should be given is, at the very least, the opportunity to come and inspect the defects, because that means that you can get your expert to have a look, which means that when the parties go to court, and I mean, let's face it, most matters do settle before you get to trial, but it's all about fairness in both, you know, fairness for the trial, so when people are in the witness box and in the trial itself, but also fairness in the lead up to the trial, when typically negotiations will be ongoing for a settlement. So, you know, if the contractor hasn't had the opportunity to inspect and hasn't been given the opportunity to appoint an expert and allow them to inspect, of course, once the remedial work has been done, that evidence of the defects has been removed. It's lost forever. Now, quite often you can get around that by having some good photographs, but not always. So when I've got defects claims for clients, I like to give contractor or subcontractor or the designer plenty of opportunity to inspect and get, you know, allow their expert to inspect. And also, you know, I like to also consider asking the contractor or whoever it is whether they will be willing, whether they're willing at their cost to carry out the remedial works, because I always think that's better for both parties, really. It's a sort of win-win. The owner of the building or whoever the claimant is gets the work done without having to pay for them, and the contractor is able to do the remedial works at the most cost-effective price. But, you know, appreciate that, you know, that's only going to happen if the contractor substantially, you know, it might not admit liability, but considers that it's liable. So I hope that answers the question.
I think it does. Yeah, absolutely. So thanks very much, Sarah. As Sarah mentioned, guys, there is going to be a procurement seminar coming up in September, so keep an eye out for that on the CECA Yorkshire and Humber events page, which again I can add to the email that I'll send out this afternoon with the slides for today's webinar and also the link to the YouTube recording. The next webinar that Sarah will be hosting for us is on Tuesday, the 23rd of May, and that's at 1 o'clock. That's preparation for adjudication. So if you've not already registered, then hopefully you'll register for that. So I think that's it then, Sarah. So thank you very much for another great webinar, and I'll see you next month.
Thanks, everyone. Thanks, Jen.
Thanks, everyone. Bye-bye.